Well, welcome to our session today, Open Meetings, It's the Law. I am Mary Ann Morey. I'm the District Consultant for Central District with the State Library of Iowa, and with me today are two very knowledgeable people. The one name I'm sure you'll recognize, Mandy Easter. Mandy has been our law librarian for 16 years, and we also have Charles Smithson with us, who is the Executive Director of the Iowa Public Information Board. And more about that here. I think most of you know Mandy. She is such a blessing to all of us in library land with all of her legal knowledge and information that she provides to us. But she also has experience as an academic, public, and regional librarian. And I enjoy working with Mandy and putting these presentations together. She provides the content, I provide the slides, and we make a pretty good team, I think, Mandy. And we also have Charles Smithson. As I said, he is the Executive Director of the Iowa Public Information Board, and perhaps you've not heard of that board before. It's an independent agency that answers questions or addresses concerns regarding Chapters 21 and 22, which are all about Iowa's open meetings and public records law. Mostly part of what we're going to be discussing today. I heard Charlie speak at an ILA conference, I believe that was just a year ago, and I knew then that more people needed to hear his message. So thank you both, Mandy and Charlie, for being here today. We appreciate your time and your information that you're going to share with us. Open meetings are sometimes referred to as sunshine laws, and I believe those exist in all 50 states. And Chapter 21 in Iowa defines the open meetings law, and as you can see, the whole purpose behind it is to make sure that decisions of a governmental body are easily accessible to the people. So basically speaking, the open meetings law ensures that a board will not be conducting questionable activities outside of public knowledge or scrutiny. And I assume you all know that your library board is a publicly appointed board of the city, and as such you need to ensure that your board meetings and information about your meetings are all easily accessible to the people. So Charles and Mandy will be talking more about this law, its intent, and the board's responsibilities in following the law. And I did hit the record button, as you all know. This is going to be posted on our State Library website as an archived webinar. It would be a great session for your trustees to watch, and that would count toward trustee training, which is one of our standard requirements for accreditation. I will just share a couple more pieces of information here, and then I'll hand it off to Charlie and Mandy. There is a handy-dandy little handbook on this topic that's available from the Iowa Freedom of Information Council. It's published by the School of Journalism at Drake University, and some of you may have this floating around in your office somewhere at the library. It's very small, but it's a nice little complement to the information we're discussing today. And this booklet covers Chapters 21 and 22 of the Iowa Code, and that deals specifically with public boards. For today's presentation, we'll be focusing predominantly on Chapter 21 about open meetings, and we'll save Chapter 22, or the bulk of it, which deals with open records, for perhaps another webinar in the future. You can get a free copy of this booklet. It's readily available on the internet, and I believe you can still purchase copies of it for around $2. But if you just go to the internet and do a generic search for Iowa Open Meetings Handbook, you should be able to find it, and the URL is there on this slide too, and we can post these slides to the archive as well, so you'll be able to hear it or read it and access it. So when Mandy and I were discussing this presentation, we thought it might be best to conquer this what is a rather heavy topic by means of dialogue. So I'm going to step aside for most of this presentation. I'm going to let Mandy and Charlie dialogue with us, but I will be keeping my eye on the chat box. So please don't hesitate to put your thoughts, questions, concerns, comments in the chat box. We want you to do that because that's how we know you're still with us. Otherwise, we feel like we're just talking to ourselves. So be active participants by making your comments and asking questions in the chat box. So we're going to dialogue now in a series of 12 questions, and I am confident that no matter how well you think you know open meetings law, you will learn something today. So Mandy, I'm going to pass it off to you with our first question here. What do all these terms mean?
Thanks, Marianne. Well, it's important to understand the definitions of the terms pertaining to open meetings laws. Our first question then is, what do all these terms mean? Iowa Code Section 21.2 is entitled Definitions, and I would encourage everyone to take a look at the words and meanings used with respect to these laws. Charlie, would you please elaborate on the types of government bodies to whom the law applies?
Can everyone hear me okay? Let's start with that. Okay, perfect.
Yeah, you sound great.
This technology is a little new to me, so I'm kind of old school, but we'll get through it. First issue under open meetings, and as Marianne's already said, it applies to your library boards. But as you guys get questions from other governmental entities, or the Public Information Board has to sort through an issue, the first thing we look at is, okay, are you a governmental body or not? And that is usually a pretty simple answer. If you're government, meaning you get tax money or you're somehow defined by the statute, you fall under Iowa Code Section 21.2, and then all of the open meetings laws apply to you. Where they'll get kind of tricky, and we'll deal with in a little bit, is subcommittees or advisory groups, and we'll talk our way through that later on. But initially, governmental body for purposes of Chapter 21 is pretty straightforward.
So private nonprofit corporations, such as library friends groups, library foundation boards, and county library associations are not subject to open meetings laws. And the same goes for meetings involving library staff, either with other staff members or with people outside the library. Would you please also talk about the definition of a meeting subject to those laws?
One of the things I want all of you to get today, if nothing else, number one is be careful of email. A meeting happens when you have a majority of the members of your board in person or electronically. So if they are sending an email and they are replying all, potentially they have triggered the open meetings laws. We actually had that question come up this morning before I came over for the webinar. There was a city council that 3 of their members were emailing each other about a topic that was part of city business. They've now triggered an open meeting. They did not set out an agenda 24 hours in advance, which hopefully all of you know, and we'll talk about in a little bit. And so they've now violated the open meetings laws because they had an electronic meeting. One of the other things I want to stress is a majority of your board can still get together if you're talking about social issues or other things that are not under their like official duties. But I would encourage you to tell your board members to be careful of that, because if someone sees a majority of the board talking, they're going to assume that it's about library business, and I guarantee you they're going to file a complaint with the Public Information Board. And we probably get at least one complaint a month that somebody sees members of a governmental body talking outside of the normal meeting and they complain. And sometimes it can be as tricky as there was a city council where a husband and wife both served on the city council. That's not something I would ever recommend to any married couple, by the way, enough to fight about without both serving on a council. But anyway, they were going home, ran into another member of the city council outside of City Hall and started talking. Well, now all of a sudden they've triggered open meetings laws. So you got to really be careful of those kind of discussions that happen outside of an official meeting.
So what about when a court trustee...
Mandy, I'm going to butt in just a minute here because we have a couple of questions, and Maria had asked about a library consortium. And Maria, I'm assuming that this is just a group of librarians who are gathering together, and from what we saw in that previous slide, those types of groups would not fall under open meetings law. Am I correct in saying that, Charlie and Mandy?
I would agree with that, as long as they've not formed a 28E, meaning they have not created a governmental entity under Iowa Code Chapter 28E, or there was some sort of other formal creation of this entity that they would not fall under open meetings. If
Okay, and I'm just seeing now she's clarified that they do have a 28E.
Maria, 28Es are subject to the open meetings laws.
Okay, good to know. So there's your answer. One other quick question here was on the email, and I think we may address this later in the presentation, but I usually advise, based upon what I heard you say, Charlie, at that ILA conference, that when a director sends a message out to the whole board, that the board members need to reply to an individual, not to all. And that was the best advice you had in regards to email conversations among board members. Is that your recommendation?
That is correct. And in fact, when I communicate with my board, I will send the email to myself and blind copy all of the board members. So the only person they can communicate with is myself. So we haven't triggered an electronic meeting. And I just told them up front, this is why I'm doing it and why you're going to see it blind copy, so that we don't accidentally trigger an electronic meeting by sending an email and everybody starts hitting reply all.
Yeah. Good idea. And I usually advise my boards that in small towns especially, a majority of a board will often be only 3 people, and it's so common that 3 of them attend the same place of worship, or their kids are in the same school, so they're at the same school functions. And my best advice is to them is just stay away from each other in those settings, because as you said, Charlie, people can misconstrue what their conversation might be about, and that kind of leads to Mandy's next comment and question.
Okay, so what about when a quorum of trustees travels to a conference together? Is that a meeting? What about when all the trustees get together for training? Is that a meeting that requires public notice, an agenda, and minutes?
Let me tackle the easier one first, which is the training. Iowa Public Information Board has said that training does not constitute a meeting so long as the members of the board don't start talking or making decisions, I should say, deliberations on issues under their jurisdiction. Obviously, they're getting training and some general things came up, but as long as they're not starting to talk about and deliberate on issues or cases or other things, training does not count. It wouldn't hurt, of course, to notice it just to cover yourself, but you would not be mandated to. As far as traveling together, it's tricky. You've not triggered a meeting if you're just talking about everything other than library board business. We all know that if you're locked in a car together, it is really hard to not talk about that kind of business. But certainly public information board's not telling anybody don't travel together. Just kind of watch what you're going to talk about. And I know some of this stuff seems kind of tough about you run into somebody, and especially from a small town. I grew up in a small town, and you have to be careful what you talk about. We're not telling people you can't communicate with each other. Just be very cautious in what you talk about, because it is amazing how the public is watching these kind of issues.
Okay, would you please describe for us what comprises a good meeting agenda that's compliant with the law?
The law requires that your agenda has sufficient information that the public knows what's going to happen. You have to have items such as the date, the time, the location, and then your agenda that's would reasonably apprise the public of what you're going to talk about. Don't do old business, new business reports, and that's it. I mean, make the one you see on the screen is actually a pretty good an agenda. The public would know what is happening, and so it doesn't have to be an exact everything, but it's got to be enough that the public knows whether or not they want to attend a meeting.
As an example, Charlie, I know that I have told boards that if they're going to be discussing a policy, they would be better off to specify what that policy is. Instead of just saying consideration of new policy, they might want to say consideration of implementation of overdue fines policy, so the public can see that and have an opinion about that topic and come to the meeting if they're so inclined to be able to express an opinion. Is that what you would advise, that they be more specific in those types of actions that they might be discussing at a meeting?
Yeah, what I would suggest is take a step back and say, okay, if I was an outsider, if I wasn't somebody that understood exactly what we were doing, would I understand what this meeting's about and would I want to come or not? So if you add a little more information to alert the public of what you're doing, that will comply with the law, and it certainly reduces the amount of complaints that may come to the Public Information Board.
And Debbie has just asked if they need to put something specifically on the agenda as a space for citizen input. And I know we're going to talk a little bit about that later, so if you just want to briefly address that now, Charlie, we'll touch on it more later.
I don't think it hurts to put citizen input or something like that. Keep in mind that you are not mandated to allow public comment. Now, I'm talking about this kind of open meeting. I'm not talking about bonding or you're doing some sort of other thing under another chapter. I'm talking about just open meetings. You're not required to have citizen input. If you're going to have it, though, I would encourage you to have some rules in place on like how long someone can talk. Can they talk about items that are going to be on the agenda that day or not? And make sure you apply them equally to everyone. Does that kind of help?
Touch more on that in a subsequent slide here in just a moment. Thanks.
Okay, regarding proper public notice for meetings. We know that the meeting agendas need to be posted 24 hours in advance of the meeting. But how much posting is enough? Is an announcement on the library's website enough, or should there also be paper postings in certain places, such as the library's main door or on a bulletin board at City Hall? Is a notice in the local newspaper required?
This is actually an interesting area where the law has not kept up with technology. For all of you that are sending out your board notices by Twitter and Facebook and Instagram and everything else, that's fantastic. The law only requires you to post it physically on a bulletin board or some other place where you normally post meeting notices. Now, I'm not telling you to stop using social media to get your notices out. I'm just saying that technically under the law, you only have to physically post it somewhere. Now, if the media requests a copy of your agenda, you need to send it to them. But otherwise, that is the posting for a meeting.
Charlie, I was formerly director in one of the metro area libraries, and that city had a code that dictated where the public boards of the city's entities had to post their meeting agendas. Is that common that the city will have that type of code?
Sometimes you'll have a city that will require the posting of notices in places other than this just kind of general bulletin board, which is required under Chapter 21. I think they need to be careful with that, because if all of a sudden someone forgets to post it in that place, you've got a violation of your city ordinance. It's not a violation of Chapter 21. If someone complained to Public Information Board saying, well, they only posted it in 2 of the 3 places they were supposed to, Public Information Board's happy if they post it in the one place they're supposed to, but that you have a city ordinance problem. And I saw someone had a question about, or had a comment that they've had people talk for over an hour during the public comment period. That's why I would encourage you to adopt rules or procedures or something that would limit how long one person gets to talk on any particular topic, and that will really help you out.
Okay, the rules for calling an emergency meeting are in Iowa Code Section 21.4. I've been asked before if the 24-hour notice is literal or if that day must be a business day. In other words, if an emergency meeting is called for Monday, is a public notice on Sunday compliant, or should it have been posted the previous Friday?
Let's talk a little bit about the 24-hour posting, because there's some confusion over what this requires. Under the law currently, you're supposed to post it 24 hours in advance. That does not necessarily mean the public can view it for 24 continuous hours. The legislature's wrestled with that issue. Obviously, for you guys and for the Public Information Board, it's preferable if you post it in a place that's viewable for at least 24 hours. Especially now with social media, I think that this is less important than it used to be. But you at least have to post it 24 hours in advance. And again, post it somewhere where the public has at least some access to it. We had a situation once where a city posted for a special meeting and they posted it in what I would consider a private governmental office. It was certainly locked for the entire 24-hour period. That's not going to count no matter what we think the confusion of the law is or is not. Emergency meetings. You can change your agenda with less than 24 hours notice if it's truly an emergency. However, what I would encourage you to do is contact the Public Information Board and talk to us about that and make sure that we know and that we're all in agreement that it's truly an emergency. If you can hold it off to another day or another meeting and properly notice your meeting, I would really encourage you to do so. But you are allowed to change things. So if all of a sudden there's been some disaster that happened in the library and you need to deal with it on less than 24 hours notice, you're permitted to do that. But again, I would encourage you to just drop us an email or call us and let Iowa Public Information Board know so that if someone did happen to complain or some issue was raised by the media or someone else, we're able to work with you on the front end of that type of issue rather than having to sort out what happened after the fact.
Okay. We get a lot of questions about whether or not trustees can attend board meetings without being physically present at them. We've touched on this a little bit already this morning, but let's expound upon it. Sometimes there's a board member wants to telephone into the meeting or appear digitally by Skype or Zoom, for instance, or by email. So let's talk about each of those methods separately. And I assume your answers will be based on interpretations of Iowa Code Section 21.8, which is entitled Electronic Meetings. So Charlie, under what conditions is it acceptable for an absentee board member to participate in a meeting by telephone?
The nice part is under the law that you have in the screen in front of you, that's if the entire meeting was going to be done electronically. If you have your board meeting and your staff is in the normal, let's call it what I would call the normal location, and your staff's there and you have some board members there, and then you have someone call in or Skype or something else, perfectly permissible. The board member just needs to be able to of course, hear and be heard so that the public can hear what that person's saying. So don't have them email in unless you're going to read the email out loud. But as long as the board member can be heard by telephone, perfectly permissible, and you don't have to do this kind of notice that they're talking about in 21.8. However, if you're going to have a purely electronic meeting, and this happens sometimes with boards, certainly at state government, some situation comes up and rather than bringing everybody in to deal with an issue, you can have that kind of meeting by telephone. Make sure that there is a place where if the public wants to come and listen to that conversation, they're permitted to. So you would still probably set up your phone system wherever you're going to have your meeting and all of your board members can call in. Just make sure that you've properly noticed your meeting and the public could come down and listen to that conference call.
So you're saying that it's okay if a quorum wants to phone in, or in fact, if all of the trustees want to meet by telephone?
As long as you've properly noticed it, the public is able to come in and listen to it. And then if you're going to have more than a majority, I would follow the requirements in 21.8 that you put in your minutes why it was necessary to have this electronic call and just say it was impossible to bring everybody in on this notice, or it wasn't cost effective or something. But otherwise, yes, if you have one or two members and everyone else is in person, it's perfectly permissible. It's always okay to do that type of electronic meeting as long as you have notice and the public has the ability to come in and hear the conversation.
So it sounds as though it's acceptable for a trustee to appear at a meeting via Skype or another technology by which she can see other board members and they can see her, But again, is it okay for the entire board to meet this way?
The entire board can meet that way, but you have to put in your minutes the reason why. And it can't be just simply that it was a matter of convenience. When I've had boards do it before that I was their lawyer, we actually had a reason. We thought that the conversation was going to take 10 minutes. It didn't make sense for the taxpayers to have to pay for mileage for all these people to come in for 10 minutes. Or you have situations where you're not going to be able to get everybody in attendance. And if you don't do a telephonic meeting, you're not going to be able to deal with the agenda item. So you can do it electronically. Just make sure that the public can still hear what you do. And so the slide you have now talks about email a little bit. I know a couple of cities that have tried to do what I would call quote unquote email meetings, and it didn't work very well because you have to set up a way that the public can see the email conversation happening in real time. From a technological standpoint, I don't even know how you do that, and it really didn't work very well. So I would not encourage email meetings at all.
I did have a question once. A trustee wanted to email her comments and votes on agenda items ahead of the meeting and then be counted as present if her communications were read at the meeting. Would that be acceptable?
I don't know that well, number one, it wouldn't count towards your quorum. I suppose if you sat and read everything, but to me, you're getting very close to kind of a proxy thing, which we really don't allow under Iowa law, so I'm not really sure that's the best way to go. I saw one of the questions being asked, if we need one or more people to make a quorum, can one of the trustees call in, be put on a speakerphone, and that's okay? That is absolutely correct, and that's what the Public Information Board does on occasion. We will have our public meeting. We have 5 or 6 of our board members there in person. A couple of out of state or out of town or just can't make it. We put them by phone. They're on a speakerphone. The public can hear them when that board member says something or votes in a particular manner. I saw another question, can and should board meetings be recorded? There's no mandate that you record your board meetings except for executive session or closed session, which we'll talk about later. Is it a good idea or not? I think that really depends. There are times it's useful to have your meetings recorded, and there's times where, frankly, it might not be. Those recordings are public records that someone could get under Chapter 22, so you got to kind of think, is that good or bad to record those things? I will say the law does permit the public to record your meetings, but you can have rules to make sure that there's still there's decorum being had and all of those kind of things. I mean, it's not like they can set up a big camera right in front of your the chair of your library board and it's distracting and those kind of things. But the law does allow the public to tape or otherwise record. You're not mandated to. It's kind of a decision on what you want to do as far as recording or taping your meetings.
Charlie, a big question that is posted here in the chat that we as consultants are often asked is this one. The weather is horrible, nobody can get out, we need these bills approved so they can get paid. Can I just submit the bills list to my trustees by email and have them say yes, they approve it? I have always told trustees and directors that no, I did not believe that was a legal action. Am I correct on that?
The only way that would be a legal action is if you noticed 24 hours in advance that email was going out and you had a way that the public could access in real time that email response.
Right.
So I think that was a very legal way of me saying, yes, you can do it, but I wouldn't recommend it. I think it would be way more of a hassle than just getting people together on the phone in that situation, explaining that you have to get these bills paid, but because of the weather, you can't bring people in. Notice it, do your phone call, and I know it sounds like kind of a hassle that you're going to have probably a 3-minute phone call, but by doing it that way rather than email, you've complied with the open meetings laws.
And Charlie, just to clarify once again, I believe you said the person calling in needs to be on speakerphone so that the audience can hear what that person is saying and so that that person has capability of hearing everyone else who's at the meeting, correct?
Yes, utilize a speakerphone so that person can be heard. You know how they vote. You know whatever statements that they make on an issue. So just utilize the speakerphone, and it's perfectly permissible.
Okay, and Keta will get to your question in a little bit, and Peg, I'm going to save your question toward the end of the session, so hang on to that thought, okay?
Okay, we tend to hear grumbling from librarians about board members who appear to be circumventing the law by practicing serial and successive private communications in which one or two board members attempt to survey the other board members or achieve some sort of consensus ahead of a regular meeting by talking with fewer than a quorum, either in person, by phone, or by email. This seems to obviously violate the spirit of the law, but is it blatantly illegal? How would your board analyze a complaint about this type of behavior?
This has become what's called a walking quorum. So, for example, let's say you had a 5-member board. Members 1 and 2 talk about an issue, resolve it. Member 1 then goes to member 3 and they talk about it and try to reach a consensus. Member 1 goes to member 4, talks about it. So you never have 3 of the 5 ever come together. That walking quorum is currently legal, although obviously for transparency reasons, that's not a great practice. The legislature's wrestled with this issue a little bit, and I think at some point walking quorums are going to be dealt with again. It's certainly not good public service because then you get at a meeting and everyone kind of knows how everyone else is going to vote because they've deliberated behind the scenes. They've just not deliberated to get a majority, so they didn't have to have a meeting, if that makes sense. I do want to say there was a recent Supreme Court case, and I don't want to bore you all with the legal dynamics of it, but now if they're starting to do this walking quorum, but they also include a staff member, and that staff member becomes an agent or proxy, kind of meaning they have the ability to negotiate on behalf of the other board members, that can become a meeting. So you really need to watch when board members say to a staff person, here's how we're voting on it. We want you to go talk to this other member, tell them what we're doing, see if they'll sign off on it, come back to us, that kind of shuttle diplomacy. The Supreme Court has said that that's potentially an open meeting. So you can still kind of do a walking quorum. I wish people wouldn't, but you got to be careful of this new, and it was a case out of Warren County. It's called the Hutchinson case for any of you that follow that. We're still kind of sorting out what it means when you have a staff member kind of act as a proxy. And I think I probably muddied the waters more than I needed to. But be careful of this walking quorum thing where you have less than a majority kind of negotiating, but they're going and talking to other members and they're just kind of doing this shuttle thing. It's legal, but it certainly doesn't comply with the spirit. And now that we have this new Supreme Court case, it does call into some question on it until we can get that sorted out.
Thank you. Let's talk about rules under which board subcommittees must operate. For instance, library boards often form subcommittees to sift through applications for open director positions, and they forward only the best resumes for the full board's consideration. Most libraries also form review committees comprised of trustees and community members who make decisions regarding citizen challenges to library materials. How do open meetings laws apply to these types of groups?
This is a really tricky area of the law, to be honest, and the law is not written very well. As a general rule, obviously, if you have a majority of your board on this subcommittee, you still have a meeting that you'd have to do notice and all of that kind of stuff. What's not as clear is if, let's say, you have one member out of the 3 on your library board that's on the subcommittee, you have somebody from the or 2 people from the public. Then you have to kind of look at what is the work they're doing. Are they really making policy decisions and can they take action? Or are they merely looking at something and then going back to the full board and saying, here are your choices? it is really very fact specific. As a best practice, obviously, if you notice these subcommittee meetings and permitted the public to watch them, you have zero issues. If for some reason you think that there is a particular subject that for whatever reason you do not want the public to hear about right away or weigh in on, and there's legitimate times that may happen, I would encourage you to contact the Public Information Board and walk through it with us. It is really a very, very tricky area of the law that has caused a lot of problems over the years. I know that's not a very good answer, but unfortunately that's kind of where we are on it. So when these issues come before the Public Information Board, we look at, okay, how was the subcommittee created? What are they really doing? And if they don't have the authority to really make decisions or are impacting public policy in some way, they probably don't have to comply with Chapter 21, but it'd be a better practice if they did. Subcommittees are tough, and every year there's legislation trying to straighten this out.
Thank you. On to the next topic. Can trustees cast secret ballots?
Unlike the long-winded lawyerly answer I just gave you, this one's easy, and the answer is no. You cannot do secret ballots. The votes have to be done in open session, and how each member voted has to be included in the minutes of the meeting. This one's easy. You cannot do secret ballots.
It's an important point, though, that you just made, Charlie, that a lot of boards are not aware of, and that's the fact that how each member votes needs to be noted. If it's a unanimous vote, that can be noted in that fashion, but if there's some dissension, then it needs to be noted in the minutes who voted which way, correct?
That is correct. If all of your members vote for something, you can just write unanimous. You don't have to list out each of their names and say they vote aye. You can just say unanimous. But if you have a dissenting vote, you need to list that person out that they dissented. Same thing if you have someone that wants to abstain for some reason, note that in your minutes. But otherwise, it's perfectly permissible that if you had a unanimous vote, you can just say unanimous and you don't have to list out each name and say, 5 yay, 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 yays. You can just say unanimous.
Okay. As you can probably guess, we get the most questions about closed meetings. Iowa Code Section 21.5 is entitled Closed Session and contains a long list of conditions which must be met before a closed meeting can be held. And because the spirit of the law favors open government, the list is fairly restrictive in order to minimize the number of situations for which a meeting may be closed. Can you summarize for us the circumstances that allow the board to go into a closed session?
There are 12 times under the law where you can go into closed session. To go into closed session requires a vote of your board, which has to be done in public session, open session. Also, before we get too deep into this, let me go back and say, for purposes of your agenda, when you're going to notice this 24 hours in advance, if you anticipate having a closed session included on your agenda, say, potential closed session, and then give a few words of why you're going into closed session. There's both a Court of Appeals case and Public Information Board rules that say it's not enough to just say closed session 21.5, but include some words like, for example, you could say closed session to discuss purchase of real estate, which is one of the reasons you can give, or closed session discuss litigation with counsel. That's one of the reasons that you can give to go into closed session. Make sure if you go into closed session, you have to record that. Unlike what we talked about earlier when we said you do not have to record your public meetings, you are required by law to audio tape. It actually says audio tape your closed session. And you're required to keep that audio tape for 1 year after your meeting. So make sure if you have a closed session, you're taping that thing, and you know for the next year how to find that tape. In closed session, you can only talk about those issues that you went into closed session to discuss. So, for example, if you went into closed session to discuss an issue with a student, like if you look at E there, it talks about schools often use this to expel or discipline a student. You can't get in there and also start talking about problems that they have with a teacher. It has to be whatever reason you went into closed session to discuss. And you can only talk about those things that are under one of these 12 categories. So if all of a sudden you think that your board wants to go into closed session and you're uncomfortable that it doesn't fall under one of these, get some guidance or tell them to wait, because this is an area where the public really pays attention to. Was all that clear? I threw a lot about closed session, and it's a pretty important thing. Oh, also
Charlie,
keep
I
in
had a
mind.
question.
Yeah,
Oh,
sure. Go
I
ahead.
just had a question one time about where does that recording need to be stored, and when I inquired about it, I don't believe it was your office at the time, but I was told that the best place for that recording is at the clerk's office. Your advice on that?
I think wherever someone knows where it's at and that it's safely deposited and locked away so that just not anyone can access that thing, because it's supposed to be confidential, and just remember where it's at for the next year. So be it at the clerk's office or somewhere secured in the library. I think that's kind of up to you. Just make sure that you know where it's at and you can retrieve it just in case there's an issue.
The next question was going to be to detail the record keeping that's required for. Could you agree that we've covered that, or did you want to add anything to that?
Again, I would just say make sure you tape closed session. Really encourage your board members to make sure that they stay on topic and limit it to those topics, because this is being recorded, and the Ombudsman's Office, the Public Information Board both have the ability, if there's a complaint filed about closed session, that we can hear that tape. Also, if someone were to file a lawsuit saying that there was a violation of open meetings laws at this closed session, a judge could hear that tape. So make sure that you record it and you know where it's at.
Charlie, I don't know if you saw the question that Peg just posted that ties in with this whole concept about open versus closed sessions, but a board member asked this library, I assume director, to leave the meeting because the board wanted to speak about a particular topic, including raises. That's not legal, is it?
I'm going to assume that's a hypothetical question, because no, they cannot have a closed session to discuss raises and gifts. Let's talk a little bit, though, about personnel, because this comes up a lot under closed session. One of the exceptions to the open meeting so that you can go into closed session is when you're talking about the appointment, discharge, hiring, performance of a person, but also that conversation would irreparably damage the reputation of the individual, and they request the closed session. For in other words, let's say that my board was going to discuss evaluating me, and I was concerned that that evaluation would irreparably damage my reputation, meaning I probably wasn't doing a very good job. I would have to be the person that would request the closed session. The board can't do it on its own. It has to be the person who's being discussed request the closed session.
And I think we touched on this topic in a subsequent slide coming up in just a little bit, but while you mentioned it, you said the employee has to request it. Does that need to be requested in writing, or is it sufficient to just make a phone call to the board president and say, hey, I want you in closed session?
It's sufficient to do it by telephone call. I will tell you, though, I would probably get it in writing. We actually saw a situation involving a school district where they were going to deal with an administrator. The administrator thought that that conversation might irreparably damage or hurt his reputation, and so he requested closed session. But then it turned out that he was saying that he didn't, and filed a complaint with the Public Information Board, but the school had in writing where he had actually requested it. So while you can do it orally, I think in writing is probably the best practice, just to cover yourself.
There's a saying in contract law that an oral contract is as good as the paper it's written on. So always write things on it in case there might be legal action. And to clarify, Charlie, do you have more to say, Marianne? Did you have another question?
Nope, okay. Go ahead.
Sorry, Charlie, no final actions may be taken by the board while it's in closed session, correct?
That is correct. Make sure they don't take any final action. So if you end up taking some sort of action, they want to take an action as a result of closed session, they come out of closed session, vote on that action in open session. No final actions can be taken in closed session. It is for the purposes of discussion on specific topics only. All actions have to come out and be done in open session.
And we're still getting some questions about employee aspects, which is actually our next slide. Let's see, Marilyn has asked, the person being discussed must be allowed to be present in the closed session. I think that needs some clarification there, Charlie.
Actually, the board does not have to permit the person to be in closed session under Chapter 21. Now, there might be some employment things or something else, but if someone called the Public Information Board or looked through Chapter 21, the person who is subject to this does not have to be permitted to be in closed session. The Public Information Board actually has an administrative rule that says government may allow in anyone that they want to in a closed session or keep anyone out. But if you're going to be meeting with your lawyer to discuss litigation, the lawyer has to be present either by telephone or in person. I mean, that only makes sense. If you're going to go into closed session to discuss litigation with your lawyer, the lawyer has to be there one way or another. But I don't think the employee has to be permitted to be in the closed session. I think they usually are in there, and it's probably makes sense, but they do not have to be. In fact, I saw one time in my career where the board was discussing the executive director, and they asked the executive director to leave. I was asked to stay as the lawyer, and the executive director who they were discussing was asked to leave the meeting.
Okay, what about when, did you have any more questions, Marianne?
Nope, go ahead.
Okay. What about when the director and the board want to discuss the staff in general, such as eliminating certain positions, not necessarily mentioning names, but when they're going to discuss sensitive issues about the staff, and they're concerned that if that gets into the minutes or the staff is present and overhears, that it's going to cause turmoil. Are there rules about that, or how should that be handled?
That is really a difficult area because, again, unless someone has requested the closed session because of the irreparable harm, and I've seen some people write that they think that's a very overused rationale. I agree with you. I think a lot of people have stretched this personnel exception far beyond what the law permits. Some of those conversations are very difficult for these people to have in open session, and you just have to do it. I mean, that's why they're on a board.
Charlie, we have a question from Marilyn. Can the personnel committee meet that's less than a quorum, and can they then discuss personnel and make recommendations to the full board for action? And I'm guessing the answer to that question would depend upon who comprises that personnel committee. If they're trustees who have been appointed by city government, I'm guessing not. But if it's a committee that's more of a community comprised committee, then perhaps so. Can you elaborate on that?
That is really tricky, and it goes back to that conversation we have about subcommittees and who's really been appointed and what are they going to do. If you're having this situation, you're running into it, I would really encourage you to call or email IPIB and let's talk about it factually before this happens. It is a really tricky area of the law, but I think forming a subcommittee is probably the best first step if you do not want it to have to be public, but you really have to watch who's on it, what they're going to be talking about, and how they make those recommendations. I wish I could give you a better answer on that, but it's really tricky.
Okay, I need some clarification on the closed sessions on agendas. Can a closed session actually be put on an agenda, since it's my understanding that the body meeting has to vote to close the session?
What I would recommend is you have, if you're not sure that you're going to be in a closed session, and sometimes your board will know, and you can put a notice on there just saying closed session. Again, a few buzzwords on the general topic, not so much that you disclose the actual reason for closed session. There's no reason to. For example, you're going to go into closed session, discuss purchase of real estate. That's all you need to say on your agenda. If you were to say on your agenda, closed session because we want to purchase this piece of real estate, and you give the physical address, you've now ruined there was no reason to go into closed session anymore. So and sometimes I know that a meeting is going in a certain way, and all of a sudden the board wants to go into closed session, and if you've not noticed it, what I would say is, unless it's an emergency, which it probably will not be, hold it over for another meeting, and then properly notice the fact that you're going to have a potential closed session to discuss that certain topic. Did that help?
I believe so, but to clarify, a closed session always has to be voted on by the members present?
That is correct. There has to be a vote to go into closed session.
Okay, I want to address the topic of the public's attendance at board meetings. What elements of the physical space in which a meeting is held foster a sense of a truly open meeting?
This is something we've kind of struggled with a little bit. Starting with, the law says that your meeting location has to be reasonably accessible by the public, and that includes the time. And one of the issues we're dealing with, there was a school district that moved their board meetings to 6 a.m. And someone has complained saying that 6 o'clock in the morning is not a reasonable time for the public to attend a meeting. We're still trying to straighten that out, whether or not that's reasonable, because for other people, is 1 o'clock on a Thursday afternoon really reasonable? If you want to attend their meeting, you have to take time off of work. So some of this is in the eye of the beholder. We have had some issues with physical space to accommodate the public. If you think that there is going to be a controversial item and that you're going to have a large turnout of the public, I would encourage you to move your meeting space to a bigger area, post your notice, let everybody know that you're going to move, and do all that 24 hours in advance. I think that will just eliminate a lot of red flags being raised. You're not mandated to do that, but I think it's better. Some places just don't have the facility size to accommodate everybody that wants to come to a meeting, and I know for some people, no one ever shows up from the public at all at meetings. So I think it's kind of up to you, but I would inject some common sense into this. If it's going to be a controversial issue and you think you're going to need more space, I would move to a bigger space and just notice your meeting, post it at the normal place you would, that the meeting is going to be held at a bigger location, let everybody know. Don't make sure that when you're letting people into the meeting, you don't start picking and choosing who can come in. That will cause some problems constitutionally as well as other things. So if you have the space, let them in. But obviously there's fire codes and other things that sometimes can limit the space, and the public needs to know and realize that and get there early sometimes.
Charlie, I'm going to post what is a very common element consideration in this type of question.
Sure.
A lot of our small libraries are one-person libraries. The director is the only employee, and the only way that the director can meet with the board is after the library is closed. And so the board will have its meeting after hours. The library has a close sign on the door, the front lights are turned off, and the board is meeting in a back meeting room. And I have told boards that's not readily accessible to the public. And they say, but we have the door open. And I say, well, when you go up to a place of business, a public building, and it's dark and the close sign is up, do you get out of the car and go rattle the door to see if it's open? So how would you address that kind of situation? What is your recommendation to libraries that are one-person employed libraries, and how can they best accommodate the public in those situations?
I think it'd be very important in that case that you make sure that, like you said, Marianne, if the public were to pull up in their car, that they don't think that the meeting's over, there's no way to get in the building. I think there has to be a light on or some other way that the public knows that they can access that meeting. I agree with you. If it looks like the place is closed down, that's probably not going to fly as a public meeting.
And Vicki just asked if it's necessary to provide seating for the public, or is it suitable to say you can go stand over there and attend the meeting that way?
Chapter 21 certainly doesn't say that you have to permit seating. Would it be a best practice? Would it probably keep the public happy to have chairs? Sure. But if someone were to complain to the Public Information Board saying they made me stand, not sit, the Public Information Board would say that's not a Chapter 21 violation. There's been plenty of public meetings I've attended over the years in the Capitol and elsewhere where I had to stand. I'm not saying it's a great idea, and I'm not saying if you have a controversial issue, empty all your seating out of the room to make the public stand, hoping you wear them down, of course. But there's nothing in the law that mandates that there has to be seating, just that the public can access the meeting.
Okay, so is there a best time of day to schedule a meeting, and is there a best day of the week for meetings?
We just kind of discussed this a little bit where we're dealing with this school board. As my grandparents would say, they thought that 6 a.m. was probably a fantastic time to have a meeting. For them, anything that happened after about 8 o'clock in the morning was too late in the day. For people like me, I would rather meet at 10 o'clock at night than 6 o'clock in the morning. There really isn't any good guidance on this. I would say inject some common sense on it. I would probably stay away from Sundays, for example. I think a lot of people, for religious reasons, probably would not appreciate that. But otherwise, it's as long as you're noticing your meeting and the public's allowed to attend, you're going to be okay. There is a Supreme Court, or not a Supreme Court, there's a court case that kind of talks about 2 a.m. would probably not be reasonable. I think anything after 9 p.m. start time and probably before 6 a.m. probably is off limits. I'm not prepared to say that 6 a.m. is a great time to start, but I think that's probably okay. So I think one of the things is get some input from the public a little bit or give them some notice. I wouldn't all of a sudden just do a big shift one day in your meeting date and time without letting anybody know. I think that's when some problems will be created. I think you'll see a little bit of guidance in this area in the future, but it's really a little hard to regulate because some of this is community standards. There's some farm communities where 6 a.m. is great. Other places, and we all know this with how involved kids are in activities now, it's really tough for parents and some people to do a 6 p.m. or 7 p.m. meeting. That's not as convenient as it used to be.
Okay. And what if a citizen wants to attend a meeting and requests some type of language accommodation, such as a foreign language or sign language interpreter?
That's not a Chapter 21 issue. I would say if that comes up, contact your city attorney pretty immediately. If they contact the Public Information Board, I don't think it's really a Chapter 21 issue, but I can see where this is going to come up once in a while. I think there probably are some accommodation things, maybe under the Americans with Disabilities Act or something else that's kind of beyond the scope of the open meetings law. So if you have this issue come up, contact the city attorney immediately for some guidance, or that person can get some more guidance on how federal law and some other things would play into this.
Okay, we've talked a little bit about the public forum section of a board meeting. What are some guidelines for interactions between the trustees and any members of the public in attendance? Do people have a right to speak at government meetings? And must the board allow someone to, I guess you've already said they have to they have to allow them to tape or videotape the meetings, but what do they have to allow the public to do?
There is no mandate in the open meetings law that you have a community forum, public forum, or allow the public to speak at your meeting. We get this complaint a lot. Someone said, well, they didn't have public comment. You're not mandated to at a regular open meeting. Now, again, there's some times under chapters outside of 21 that you might have to, but just as at a regular, what I would call a regular library board meeting, you do not have to permit the public to have comment, period. They're allowed to access the meeting. They're allowed to access the records from the meeting, but you're not mandated to allow them to speak. And again, if you're going to have a public forum, I would have some policies and procedures in place that place time limits on how long someone can talk, and I would stick to it. So that if you have someone going over 3 minutes, you have a strong chair or someone that's designated as kind of a sergeant at arms say your time is up and cut them off and treat everyone equally. I know sometimes we get the cave people who are the citizens against virtually everything. No matter what you do, they want to get up at a public meeting and talk about how bad everything is. You can't let the pro side talk and not the con, is what I'm trying to say. So if you're going to allow a public comment period, make sure you treat everyone equally. But you're not mandated to have one. And you're certainly permitted by law to put restrictions in place to maintain decorum and to be able to move your meeting along.
I like the way the Freedom of Information Council states it. They said that an open meeting allows the public to watch a board work, not necessarily to participate in the meeting, but to watch the board work.
Correct. I think that's a great way to put it.
We've got a couple of questions in the chat box here. One from Vicki and Charlie. I assume you can see that there about if a member of the public brings up a topic that perhaps is not on the agenda, does the council, or in our cases the library board, would they have to address it? And then Susie is saying that what if the board addresses a question to someone who's not specifically a trustee, can that person respond?
To answer Vicky's first, that's correct. I mean, public comment period does not mean that the council is somehow mandated to vote on the issue that that person wants. In fact, a lot of times someone from the public might bring up something at a public meeting that you've not noticed in any way. It's not on your agenda and you couldn't vote on it that time anyway. The other question was the board directs a question to a staff member of the public, can they respond? The answer to that, I think, would be yes, you obviously can do it. Certainly relying on staff. I would be hesitant to too often throw things open to where any member of the public or a specific member of the public could answer a question, just because now all of a sudden you've invited maybe some public comment. But certainly a board could ask a staff member, would they assist in answering a question? Perfectly permissible.
Okay, and regarding board meeting minutes, what should they contain? How detailed should they be?
Your minutes are not required to be what in the lawyer field is a verbatim transcript. You do not have to write out every single thing that happened. But you do have to give the public the information on what did happen, meaning, as we've already talked about, the outcome of votes. If there were any decisions made, those things have to be included in the minutes. You do not have to do a laundry list of all the comments that were made. You can summarize some things. Discussion was had on this item, and then there was a motion to do X, seconded by this person, and then you detail how the vote turned out. So your minutes, again, don't have to encompass everything. They just have to cover what action was taken at the meeting, so the public knows if I wasn't there, kind of what happened. Make sure your minutes track back to your agenda. That's a good way to make sure that you know that you dealt with items and how those items turned out.
Okay, and I'd also like to add that procedural manuals, such as Robert's Rules of Orders, do have sections on what should be in the board meeting minutes. So if in doubt, look to those. And this is a big question we get. How soon should meeting minutes be available to the public in response to a request? But barring specific requests for them, how soon should minutes be available? either posted on the library's website or in their newsletter or whatever? And do they have to be approved by the board before they can be released or posted?
Let me take this from a government transparency perspective first. I think that some of you might fall under some publication requirements of your minutes in local newspapers. That doesn't come under chapters 21 and 22, so I'm not going to speak about that. All of you are probably aware of that. As far as when minutes can be accessed as a public record, I think immediately, but I would stamp on there draft, or certainly let the requester know these are unapproved minutes, so you're kind of getting what you ask for. Because I know sometimes you might be hesitant on giving a public record and saying, well, here are the minutes, but I would let them know that they're unapproved minutes. There might be changes. Do you really want them now, or do you want to wait until these are final approved minutes so that they're accurate and approved? So I think you need to make them available as soon as you can, but just let someone know if you're getting a public records request, that's fine, but you're getting unapproved draft minutes, and that may have the requester want to wait.
Okay. The Iowa Supreme Court ruled that meeting packets prepared for board members' information ahead of a meeting are public records. If a member of the public requests a copy, the librarian should provide it at cost, correct? And should the director distribute packets to the audience attending a board meeting, or should copies be handed only to those citizens who specifically request one?
Board packets are public records. What you hand out at a meeting, I think, is kind of up to you. Do you want to have some additional copies so that people can have them? I think that's a nice thing to do. You are never mandated to kind of anticipate records requests, if that makes sense. I just think probably having some extra copies there would be useful. Or if someone shows up, because I know some of you probably have board meetings where you might have no one from the public or only one or two people, and then all of a sudden you have 3 or 4 show up some night, and you wanted to go back and make a couple of copies for them. I just think it's a nice thing to do, but I don't know that you're mandated outside of an open records request to provide it. So I think some of it is kind of government service versus what is mandated under the law, if that makes sense.
Absolutely. And our last question, Charlie. Who is responsible for ensuring that library board members are informed, trained, and educated about open meetings laws?
The mandate is on your trustees or your board members to make sure that they're up to speed. Obviously, whatever assistance you can give them. We talked a little bit about this handout from the Iowa Freedom of Information Council is very useful. I would direct them to the Public Information Board website or to call or email us. We're always eager to help, but it's ultimately the governmental body or the governing board that's subject to the open meetings laws. So they need to know what they're doing to avoid trouble. Open records a little bit different. Anybody in government that's the lawful custodian or somehow has control of a record can be open to a complaint. But in Chapter 21 open meetings, it is actually your library board itself.
So when
I will just add. Oh, go ahead, Mandy.
Oh, okay. When there's an accusation that the law is not being followed, where does the burden of proof lie?
And I was just going to intercept before you asked that about this training aspect, that your district consultant will routinely, we do this all the time, we will come to your library, we will present training for your board. We've got basic presentations like the one you see here, trustees, who we are and what we do. We have more advanced training sessions available, and we have a lot of sessions that are archived on our webinar that are for trustees too. And don't forget about the trustee handbook on our website, that you should have every one of your trustees read that handbook as well. Sorry, Mandy. Had to put in my plug there.
It's okay.
I think we talked about the burden of proof for a little bit about complaints. Let me spend about 30 to 60 seconds on the complaint process. Someone from the public files a complaint with the Public Information Board. The first thing we do is get that complaint in the hands of the government being complained about and ask for their response, because it's amazing at how many times the person from the public, there was a misunderstanding or there was a very rational reason under the law why something happened, and then we go back to the member of the public and explain what happened, and the complaint gets dismissed. We do have a 60-day statute of limitations. So that is an extremely short statute of limitations. So in other words, if someone thought that you held an illegal meeting, they would have 60 days from the time period of that alleged meeting to file a complaint, or when they should have reasonably found out about it. So it's a short time period. A lot of the complaints end up being dismissed because government understands the law much better than people from the public. And that's not criticizing anyone at all. It's just how it is. But during that initial period, if there is a complaint, it's really beneficial to the Public Information Board staff if you comply with the investigation. Let us know your side of it. Let us know what happened, and we can usually work our way through it.
So what if a library director or a library trustee receives a complaint that the board is violating open meetings laws? Is that something that can be handled by the director or the trustee?
As far as something they can just fix, or do they have to turn it over, or?
Sure. Should their next step be to address it at a board meeting, or can they perhaps just provide some documentation? Should they call your office?
I would have them call our office to at least alert us that the issue's been raised. But if you can take care of things back in the home community, I think that's always a great way to start. And a lot of times what happens is that you have the public that thinks that they know how something should be, or they're mad about a particular issue. And if somebody just talks to them, a lot of these things end up not ultimately being a problem.
Sure. And lastly, what could be the consequences of the board violating an open meetings law?
Ultimately, there can be a fine imposed, and it increases depending on whether or not there was an intentional violation. Worst case scenario, somebody can be removed from a board. I mean, things almost never get to that level in Iowa, which is fantastic. I'm glad we usually don't get there, but you need to let your board members understand there can be civil fines and removal from a board for violating these things. So they are serious. And although I want to stress that we deal with most things informally as we can, they can turn out to be serious matters. One question I'd like to answer very quickly. I saw someone ask, what is a retention period for public records? Other than the closed session tape, which we talked about, you have to keep for a year, there really is nothing on libraries and other local governments on how long you have to retain a public record. It's different for state agencies. State agencies have a very specific time period for how long they have to keep certain records. It's got its own code chapter, but that chapter doesn't apply to locals. What I would say is make sure that you have some sort of rule or policy or something else that's clear on how long you keep a record. What you don't want to have happen is someone does an open records request and then you go out and destroy that record they're requesting to avoid that request. That's going to create a problem. But if you already had in place that after, let's say, 1 month, after 1 month, we shred any of the minutes or whatever from a public meeting, and you always do that. That's one thing. So we don't get into record retention at Public Information Board. But if you're going to just make sure that if there is a records request, you don't go out and destroy that record they're seeking, and kind of make sure that you have some procedures in place. And I know Marianne didn't want to get into open records too much, but I just saw that question came across.
Vicky's just asked a question. I'm going to do another shameless plug here. Vicky asked about where, maybe you're probably going to say the same thing. Where can a director get a list of what needs to be retained as far as records? And Mandy and I did a session called Reliable Records Retention. We did that a couple of years ago at least, but it's still archived on our webinar, Vicky. So Vicky, send me an email after this session and I'll send you the link, the direct link to that recording. And we have a few minutes left. Amanda, did you want to say any more about the records retention there?
I want to say that most libraries rely on the Iowa League of Cities record retention And that manual says that board meeting minutes must be kept permanently.
All right, question and answer. I do have a few that I saved from early on, and this kind of answers, Mandy, you just answered Ketta's question, do we need to preserve a recording? Ketta, I think Charlie answered your question about the physical recording as a recorded audio type of recording from a closed session that does need to be retained for 1 year, and it's best practices that we have been told, as Mandy just said, to keep those types of minutes indefinitely. Ketta, I'll tell you too, and someone has asked for the link as well. I'll probably send this out with a notification regarding your CE survey and certification, but I'll send that link for the Reliable Records Retention webinar as well. Peg has asked, this is the big question. Charlie, we get asked this all the time, which is why people ask, can we have a vote on email? The reason is because of paying bills, and you did address that once, but Peg has asked, can I pay bills without seeking approval? And Peg, I would recommend that you devise a policy whereby your board has given permission for any normal routine type of purchase and expenditure that has already been approved by them in your annual budget, that such items can be submitted for payment. This would include things like your utility bills or materials purchases that, again, fall within the budget they have already approved. But then you must present those on a list afterwards just so that they have a running total of what that all is. Any out of the ordinary or more expensive purchases, you certainly need your board approval up hand first before you would submit those for payment. And I have been told that that is legal, and Charlie and Mandy, I'll rely on you to correct me if I'm wrong there.
To me, that's a perfect way to handle it. The question kind of goes beyond the scope of Chapter 21. I would say don't, as we've already talked about, don't send an email to the board for permission because you've created an electronic media or electronic meeting problem. I think, Marianne, the advice you've given is get some prior authority up front at the beginning of things is the way to go.
And Debbie has asked, if a member of the public brings up a topic not on the agenda, can the board even discuss it because of the fact that it's not previously been posted on the agenda?
I think the answer to that is no. Then they just say thank you, and we will consider that at an upcoming meeting. And just explain so it doesn't look like they're kind of just blowing off a member of the public. Just say, you know, because of an open meeting, we've not noticed that thing. We'll take it up at a future meeting.
Okay, and I don't see any other questions. I think I caught them all as they came in. If I missed yours, please resend it here.
I think Sue might have asked.
Sue had one.
If you have a subcommittee that's truly a governmental body, do they have to take minutes at their subcommittee meeting? The answer would be yes. They're treated just like any other governmental body. Notice the subcommittee meeting. Make sure they take minutes of who was there and whatever actions were taken.
Someone's asking, is it recommended to have someone from the Friends or the Foundation report at a board meeting? And I'm sure Charlie will say that's not a requirement, but I will just say as a former director that I think it's a nice thing to do, that you want that good communication between your board and the members and representatives boards of your Friends and Foundation group. Mandy and Charlie, any comments on that?
Right. That's not part of the open meetings laws at all, so they can do what they want.
Yeah, I agree with that. I saw someone ask, can someone who records the meeting post it anywhere they want to? And I know what's driving this is kind of the social media thing. I think the answer is yes. One reason we've all got to be careful at public meetings on what we say and what we do. The internet has completely changed how we act.
Yeah. And I'll just add another plug-in for your district consultants, that if you have any questions about parliamentary procedure and how to conduct more effective meetings, we will be happy to come to your library and discuss that topic with your boards. I know I hear from directors all the time that say, oh, we have these 3-hour meetings, and under normal circumstances, your library board meeting should not be lasting 3 hours. And I would say that it's probably due to a lack of staying on the topic, having a good agenda, and sticking to it. So we'll be happy to come out and provide some training in that regard, too. I do have our contact information up here, so feel free to contact any of us if you have any questions. And I am so grateful to both Mandy and Charlie for all of their fantastic information and input into today's webinar. And I'm guessing most of you learned at least one new thing about open meetings. And it looks like Gloria has a question here. Someone comes with a complaint, the board's not allowed to discuss it, but can say we will have that on the agenda next month. That is correct as we've understood it, Gloria. Charlie,
That's
that is, yeah.
That's the perfect way to handle it, because otherwise you have potentially put yourself in an open meetings problem, which you don't want to do. So just tell the person thank you. We may consider this in the future.